The courtroom buzzed with tension that Tuesday morning, and Karen Whitfield's smug confidence practically filled the air from the other side of the aisle. She sat poised in her sharp power suit, lips pressed together in that signature look of moral superiority, murmuring urgently to her attorney as though victory were already hers. The HOA president clearly believed she was about to put the uncooperative rancher in his place. At least, that was her plan until Judge Morrison brought the session to order and asked whether I had counsel present. I rose deliberately, straightening my tie with the calm habit of decades in courtrooms. Your Honor, I will be representing myself today. Across the room, Karen's attorney, a young lawyer named Bradley Cooper, actually let a smirk cross his face. The poor guy had no clue what he was walking into. Very well, the judge replied evenly. For the record, please state your qualifications. I cleared my throat. Thomas Mitchell, retired attorney. 35 years with Mitchell and Associates, specializing in property law and civil litigation. Admitted to the state bar in 1987, the smirk disappeared from Cooper's expression in an instant. Karen's jaw slackened for a split second before she snapped it shut, trying to regain composure. Life at Cedar Ridge Ranch had been chosen for one reason: peace. After a lifetime of high-stakes trials, depositions, and corporate boardroom wars, I'd bought the 100-acre spread precisely because it offered solitude. No close neighbors, no restrictive covenants, just open land, my horses, and the occasional weekend visit from my grandchildren. The ranch had belonged to the Henderson family for 3 generations before I purchased it. Old Jim Henderson had been crystal clear during the closing. This land had never belonged to any homeowners association. The closest development, Willowbrook Estates, sat 2 miles away, separated by a stretch of county-owned property and my clearly marked boundary line. For the first year, everything was idyllic. Then Karen Whitfield was elected HOA president, and things changed. My initial run-in with her happened on a cool October morning. I was fixing a stretch of barbed wire fence when a gleaming white Lexus SUV rolled up to my front gate. A woman in her mid-50s stepped out, perfectly highlighted hair, clipboard clutched like a weapon. "Excuse me," she called in the commanding tone of someone accustomed to instant compliance. "I need to speak with you regarding community trail access." I set my hammer on the post, walked over, and kept the gate firmly between us. "Can I help you? I'm Karen Whitfield, president of the Willowbrook Estates Homeowners Association," she declared, as though the title should impress me. "We're establishing a new interconnected trail network for the community, and we need to secure an easement across your land to link up with the county hiking trails." I nearly chuckled. "Ma'am, this is private property. It's never been part of your HOA." Her polite smile stiffened. "That's precisely what we need to discuss. The community has voted that linked trails would serve the greater good, boosting property values and encouraging healthy outdoor activity for everyone. That may be wonderful for your neighborhood," I answered evenly, "but this ranch has never belonged to Willowbrook Estates. It never will." She tapped her clipboard sharply with the polished fingernail. "Mr. Mitchell, I'm not sure you grasp how these matters are resolved. When the majority decides something benefits the whole, a single holdout cannot be allowed to obstruct progress." That was the moment I realized this woman would become a serious problem. "Ma'am," I said, "I understand completely. My answer is no. Have a good day." I turned and returned to my fence work. Behind me came an indignant huff, followed by the slam of her car door. Over the following 6 months, her tactics grew steadily worse, from irritating, outright unlawful. First came the official HOA letters, printed on impressive letterhead, insisting I attend board meetings I had zero duty to attend. Then came repeated complaints to the county about non-existent zoning or code violations. Each one forced me to meet with inspectors, who invariably left shaking their heads at the absurdity. She even arranged community nature walks that stopped right at my fence line, where groups would stand, point, and snap photographs as though my ranch were some kind of exhibit. The real escalation arrived in April. I pulled up to my rear gate one afternoon and discovered the heavy padlock had been cut. Fresh tire tracks scarred the dirt road leading into my land, and bright new trail markers had been nailed to trees along the private drive. I spent hours pulling them down and immediately installed motion-activated security cameras. The footage told the story clearly. At 2:00 a.m. the following Tuesday, Karen herself appeared on screen, bolt cutters in hand, approaching the new lock. I watched her slice through it, then drive onto my property with 2 fellow HOA board members. They spent nearly an hour hammering additional markers into place. The next morning, I hired a welding crew to install a heavy steel gate set in concrete posts. I also had my former attorney send a formal cease and desist letter to Karen Whitfield and the entire HOA board. That's when she made her fatal error. She filed suit against me. The complaint was personally served on a Friday afternoon by a process server who looked almost apologetic. Karen Whitfield and the Willowbrook Estates HOA were suing me for malicious obstruction of community amenities, interference with established easements, and my personal favorite, maintaining a public nuisance. They demanded immediate removal of all gates and barriers, $50,000 in damages, and reimbursement of their legal costs. I read the document twice, torn between amusement and irritation. Her attorney had lobbed every possible theory at the wall. Claims of historical use, implied easements, even a fabricated story that my parcel had once been part of a larger tract supposedly encumbered by public access promises. All nonsense, but nonsense that still required an answer. That was when I decided to reactivate my bar membership. No sense paying someone else to do work I could handle far better myself. I filed my response, denying every allegation and asserting counterclaims for trespass, harassment, and defamation. Then I began preparing in earnest for what I knew would be a very satisfying day in court. Karen had no idea she had just declared legal war on a man who had spent 35 years making attorneys like her lawyer look like amateurs. The preliminary hearing arrived on Tuesday morning. As I mentioned at the start, Karen swept in with her full entourage, her attorney, 2 HOA board members, and someone scribbling notes, presumably for the community newsletter. She even wore a tiny HOA president pin on her lapel, as though it granted her extra authority in the eyes of the law. Judge Morrison was a no-nonsense veteran in her 60s whom I had appeared before many times during my active years. At first, she didn't recognize me. It had been 5 years since I retired, but the flicker of recognition came the instant I stated my credentials. "Mr. Mitchell," she said with a small, knowing nod. "Welcome back to my courtroom." Bradley Cooper rose to deliver his opening statement. The young attorney was pure theater, gesturing dramatically, voice rising and falling as he described me as a bitter, antisocial hermit deliberately denying wholesome families the chance to enjoy nature's beauty. The courtroom remained thick with anticipation as Bradley Cooper concluded his opening remarks. He insisted the trails had been in informal use for decades, accused me of essentially holding the entire community hostage, and portrayed Karen Whitfield as nothing more than a dedicated public servant fighting for her neighbor's benefit. When it was my turn, I kept everything straightforward and measured. "Your Honor, I have in my possession the original 1952 deed to my property, the certified survey from my 2021 purchase, and notarized affidavits from the previous 3 owners covering more than 60 years. None of these documents shows any easement ever existing on this land. At no point has this ranch been included in any homeowners association, and at no point has public access ever been granted or implied." I placed each document deliberately on the counsel table in front of me. Across the aisle, Cooper's earlier confidence began to crack visibly. "Furthermore," continued, reaching into a manila folder, "I have security camera footage documenting Miss Whitfield trespassing on my property on at least 6 separate occasions, including personally cutting padlocks and placing unauthorized trail markers without permission." I handed the judge a set of clear, time-stamped still images printed from the recordings. I also submit 17 harassing letters sent by Miss Whitfield on official HOA letterhead, records of 9 baseless complaints filed with county agencies, and evidence of a deliberate, coordinated effort to tarnish my reputation within the surrounding community. Judge Morrison's eyebrows lifted as she examined the photographs. "Miss Whitfield, she asked directly, "Is this you in these images?" Karen's face had traveled from smug pink to deep crimson to something close to purple. "Those photos were taken completely out of context," she stammered. "The community desperately needed those trails. So you admit you entered Mr. Mitchell's private property without authorization?" The judge pressed. Cooper shot to his feet. "Your Honor, my client was operating under a good faith belief that an easement existed." I cut in smoothly. "Your Honor, I would like to introduce Defense Exhibit C, an audio recording of a conversation between Miss Whitfield and another HOA board member. In it, she states, and I quote, 'I don't care if he owns it. We'll make his life hell until he gives in.'" A stunned hush fell over the courtroom, broken only by Karen's sharp gasp. "That was a private conversation," she cried. "Recorded on my own property," I replied evenly. "Your voice carried clearly over the fence line during one of your organized gatherings at my boundary. This is a single-party consent state, Your Honor. The recording is entirely lawful." Cooper tried to recover, falling back on appeals to community benefit and the greater good. But the momentum had decisively shifted. Judge Morrison had heard enough. "Counselor," she said to Cooper, "does your client possess any concrete evidence whatsoever of a valid easement? Any document, map, or record that supports these assertions?" He rifled through his binder with growing desperation. "We are continuing to research historical records, Your Honor, so the answer is no," Judge Morrison stated flatly. She turned to me. "Mr. Mitchell, do you wish to pursue your counterclaims at this time?" "I do, Your Honor. I am seeking compensatory damages for repeated trespass, reimbursement of legal fees, and a permanent injunction barring Miss Whitfield and any representatives of the Willowbrook Estates HOA from coming onto or within close proximity of my property." Karen surged to her feet. "You can't do this. I'm the HOA president. I have authority." The gavel cracked sharply against the bench. "Miss Whitfield, you will sit down and remain silent, or I will hold you in contempt of court." The judge returned her attention to me. "Mr. Mitchell, the evidence you have presented appears overwhelming. I am prepared to grant summary judgment in your favor on the plaintiff's claims." Cooper made one final, frantic bid. "Your Honor, we respectfully request a continuance to allow us to gather further evidence." "Request denied," Judge Morrison said without hesitation. "I have seen more than sufficient to rule." Over the following 20 minutes, she methodically dismantled every element of Karen's complaint while affirming each of my counterclaims. When the final ruling came, it was crushing for the opposition. All of Karen's claims were dismissed with prejudice permanently barred from ever being refiled. My countersuit succeeded in full. $15,000 in damages for trespass. $5,000 in attorney's fees, a conservative figure could easily have justified at triple that amount, and a permanent restraining order mandating that Karen Whitfield and any HOA agent remain at least 500 feet from any portion of my property. But Judge Morrison was not finished. "Miss Whitfield," she said sternly, "your conduct in this matter has been egregious. You have misused your position, harassed a law-abiding landowner, and squandered valuable court resources on meritless litigation." She shifted her gaze to Cooper. "Counselor, I strongly advise you to refresh yourself on the state bar's rules concerning due diligence and frivolous filings. Consider this your formal warning." Then came the decisive stroke. "I am referring this matter to the district attorney's office for consideration of criminal trespass charges. Additionally, I am directing the clerk to forward a copy of today's ruling and the full record to the Willowbrook Estates HOA board with my recommendation that they immediately evaluate their current leadership." Karen's composure was shattered. "But I was only trying to help the community," she wailed. Judge Morrison's reply was glacial. "No, Miss Whitfield. You were attempting to coerce a private citizen into surrendering rights he never owed you. There is a clear distinction." As we exited the courtroom, Karen found herself immediately surrounded by furious HOA board members who had been observing from the gallery. Angry murmurs about emergency sessions and no confidence votes filled the air. Cooper slipped out without so much as a glance at his former client. 3 days later, a certified letter arrived from the Willowbrook Estates HOA. Karen Whitfield had been removed as president by unanimous board vote and permanently barred from ever serving in any leadership capacity. Again, the criminal trespass case moved forward. 2 months later, she entered a guilty plea to misdemeanor trespass, receiving 12 months of probation and 500 hours of community service expressly prohibited from involving any homeowners association activities. The most satisfying chapter came 6 months after the verdict. A state law school invited me to deliver the keynote address in their continuing legal education series on property law and civil litigation. My chosen topic, When Karens Attack, a case study in homeowners association overreach. I presented the full record security footage, court transcripts, and all. The recorded lecture quickly spread across legal education platforms and became widely viewed. Karen's intended legacy of a grand interconnected trail network never materialized. Instead, her name became synonymous with the cautionary tale taught to future attorneys about the perils of abusing authority and severely underestimating one's opponent. Word eventually filtered through legal circles that she had relocated to another state. Her house in Willowbrook Estates sold at a substantial loss. The newly constituted HOA board sent me a formal letter of apology accompanied by a generous fruit basket. As for the $20,000 total in damages and fees, Karen's check cleared without issue. I donated the entire amount to a legal aid organization dedicated to assisting homeowners battling abusive HOA practices. In recognition, they named their new conference room the Whitfield Warning Room. The irony drew quiet chuckles from everyone who heard the story. Last anyone in the local legal community heard, Karen was employed as a receptionist at a real estate office 3 states away. Her ambitions of HOA dominance ended beneath the combined weight of a restraining order, a criminal conviction, and legal expenses that very nearly ruined her financially.